session. So we're going to go ahead and take our seats, please.
We're
going to go ahead and call this work session to order on ordinance.
Yes, sir.
So members of the audience, if you can please, we're going to get started. I'm going to call this work session to order of AO number 2019-50 on trapping. Mr. Peterson.
Thank you, Mr. Chairman. I'm going to do a little introduction about this ordinance. The reason I'm bringing this forward, I think it's an important public safety issue. I've received numerous emails from people who have their pets caught in traps, and it's a very traumatic experience. We're, I think, extremely lucky that someone's child or an adult has not been trapped at this point. And I also think I'm going to try to get some information out about what actually is already currently on the books in Anchorage. And it's been against the law to trap in the Anchorage Bowl for many, many years. It's been in Title 25 for a long, long time. And so there might be people out there that are not aware of that. What this ordinance will do is will extend the trapping regulations a little further into the areas of Chugach Eagle River and into Girdwood. And it's written to mimic the regulations that for trapping in Chugach State Park. 50 yards each side of an established trail, a quarter mile from a trailhead, and a quarter mile from any building, an established building like housing. And so that's the basic overview, and Dean can get into more specifics.
Thank you, Mr. Peterson. So before I turn it over to Mr. Gates, I'm reminded that we need to do introductions. So we're going to go ahead and start with Mr. Gates. Go around.
Sure. Oh, I'm sorry. Dean Gates.
Dyson.
Rivera.
John Weddleton.
Forrest Dunbar.
Austin Quinn Davidson.
Cameron Perez Rodeo.
Meg Zalatow.
Pete Peterson.
Jim Farmstead.
All right, thank you. Go ahead, Mr. Gates.
Okay, so I guess the easiest thing for me to do is never want to take up too much time because some people probably want to talk about this ordinance today. So I'll just run down what this does. Yeah, and I will try to speak up. Please just interrupt me if I need to speak up. So we had a bill that was introduced at the House in the vascular legislature by Brett Josephson that was pretty much going to say municipalities can enact these kind of ordinances. That bill didn't move and it didn't get passed, but we recognize that the municipality of Anchorage is a home rule municipality under the Alaska Constitution. In our charter, we have all legislative powers not prohibited by law or charter, so it's very broad. So we feel that, or at least I do as the drafter here, that we can enact this kind of ordinance, this kind of regulation for public safety purposes. It's got to be reasonably related to public health, safety, and welfare. So that's what this tries to do. I would also recognize, though, that there's layers here of preemption issues. The ordinance is designed to be area-wide, like all criminal and ordinances are. This is about lands and what you can do on land, and where you can put traps on land. So we have federal lands, state lands, municipal lands, private lands. I believe that this would apply everywhere, but maybe there might be some enforcement issues unless we have certain additional steps to do. So I would mention that, and I would suggest that I've given a little more time to work on that and some legal issues before this passes. With that said, the ordinance in section 1, starting on page 2, it is basically trying to keep it straightforward and simple. Subsections A and B, subsection A is almost exactly identical to state board game regulation that applies to Chugach State 50 yards of sided trail, developed use trails, and 1/4 mile trailheads, campgrounds, permanent gardens, and described. This is also intended to say, subsection B is about game traps, snares having identification. In Chugach State Park, the Board of Game Regulation requires trappers to mark their traps with an identification number that they obtain from the state of Alaska, from the, I think, superintendent of Chugach State Park. And, correct me if I'm wrong, but I see some state folks here, so please let me know if I misstate anything. So this part B about marking the trap, again, trapping, hunting, fishing is regulated by the state of Alaska. Well, there's a preemption issue there. Taking a game fish is something that municipalities can't do. We can't regulate that. But this isn't intended to do that. Right? We're not regulating the equipment, the tackle and gear, the seasons, bag limits, type of animal. That doesn't do anything with that. This subsection B says you need to have some kind of identification. So it's only for purposes of being able to identify if there's a violation and who's responsible for it. So I guess there's maybe some debate about this regulating the gear itself. So as I mentioned, there's a legal issue that we want to look at further before this passes. So we have some definitions, and the first one for developed trails are similar to what the state law has. And again, I just simply refer to the Alaska Department of Fish and Game statute. Trapping as well, it's simply different to the state's definition. The definition for public use trail, this one's very broad, and that definition is very broad, and I've seen from the comments that we've received from the public so far, this is going to be a contentious definition, so we're going to look at that one further. And then we have the fine schedule, the trapping or taking the trap, and if they were to mark, and those fine amounts are just arbitrary lines here, so we include those. Then in section 3 and page 4, it's to be adding a very specific prohibition. Subsection A, 25/740, applies to municipal lands except in areas where it's specifically designated for such use. So prohibiting sport, commercial hunting, or trapping of wild game animals. We already have subsection B on page 5, line 17, that on any municipal land, the person may arise to imposing provoke traps that will use any animal. So that's not changing. I've left that in here for reference for context.
Before you
section
continue,
4,
I have a question from Mr. Constant.
Thank you. So failure to mark trap or snare, is that every single trap each time? Right, so if you have 10 traps on the line, that would be $2,000. Section 2, the table.
where would we use in subsection B, use all traps or snares must have an identification mark. I think in application and enforcement, and I would defer to enforcement officer's perspective here, I think it would be foolhardy to charge each one, for a single violation fine. You have a trap line, 10 traps, for example, $200 each. I mean, if I were the enforcement officer, I wouldn't do that. I would say $200 to fix this problem.
But if you had a trap here and then 100 feet down another trap and 100 feet down another trap, I would think that would each be a violation. And so that's a conversation point we should sort through.
Not yet, at some point.
Okay.
Thank you, Mr. Johnson. Go ahead.
So bringing that to the ordinance, page 5, section 4. This is a current code. There's a criminal offense. The cruelty animals chapter in 85540. I talked to the prosecutor about this section a while back, it's really intended to apply to domestic animals, cats, dogs, snakes, ferrets, and prohibit people from setting traps, for example, with their neighbors, like their dog barking, they use that traps for them. That's really something it's really intended, that's the purpose of it. I just didn't the subsection B says doesn't apply to this level of trapping that we're talking about this ordinance. The Mr. Prosecutor also told me, I should say former Mr. Prosecutor, that they're working on revising some Title 8, including this section. So when we develop section 855, 40, garbage attention, since it might be changing soon. So, and then finally, the effective date is 40 days after passage, and that's just a standard anytime rule, adding the offense with the civil citation or criminal charge for 30 days so that things can be updated before all these citations which we contain the prosecuting system, things like that. So, I guess I'll hand it back.
Sure. Thank you, Mr. Gates. So any questions for Mr. Gates before we go on? I believe Mr. Peterson, you want to do audience?
Yeah, we can do that.
Okay. Sure, Ms. Quinn Davidson.
Dean or Pete or Suzanne. So in section 3, A10 that you've added, why wouldn't that already be covered by B1? So A is on muni land, you're not allowed to do the following things, and you've added sport or commercial hunting or trapping. But then on B is another list of things you can't do on muni land. It's confused why there's two different lists, right? But it says kill or injure any animal.
That's a very good question. If you look at the leading sentences, there are different. A says except as otherwise permitted. Except in areas specifically designated for such use in accordance with law. So, Board of Game regulations are allowed, Title 16 statutes regulating Department of Fish and Game, that's law. So maybe they designate areas we can do it so that sport and commercial trapping, I think belongs here, so we're not prohibited.
But B says
I
that
guess
too.
they'll say elements for lands, D2. There might be some redundancy, of course.
Okay. I mean, it's
I
fine
guess
with me,
it'll
but
just be
I think Mr. Schutte has something he wants to add.
Yeah, thank you through the chair, Chris Schutte, Austin Community Development. One of the easiest ways to think about both the section A is prohibitions except in designated areas. So if you take the first one, for example, camping, we do have municipal land where there are campsites or campgrounds. So everything in the list of item A is prohibited unless in an area allowed. Everything in item B is just writ large. Everything's prohibited on municipal land writ large.
But can I ask a follow-up question? It says, B says, on any municipal land, no person may, except as otherwise authorized by law. So it's the same thing.
Yeah, so that secondary clause is the explanation that Dean gave, which is sometimes there will be other jurisdictional rights, such as state board of game, that we don't control. So item A is, we don't allow it on our land unless we say you can do it. Item B is, we don't allow it on our land unless someone else says.
Okay, thank you.
Thank you, Ms. Quinn Davidson. Sure.
Also, as one more thing, there's a maxim of interpreting law statutes or ordinances where a more specific law governs over more general law, like let's say one's very general, A10 is a bit more specific.
Thank you, Mr. Gates. Any more questions for Mr. Gates before I turn it over to members of the public? Mr. Constant.
I've heard some conversation from people who are concerned about bears up on the upper hillside. Where does an authorized hunt or trap fall into this mix? How could that be authorized? Because I know there are people who are arguing for that, and I don't know if it will be successful or not, but I definitely have been hearing.
Who would like to answer that? Mr. Gates.
I realized this past week that we probably need to add an exception here for trapping activities by authorized by the municipality, for the school officials or things like that. I think that's. I'm sorry, I think there's an exception not to have the language, but I can recognize that to me an exception for official activities.
Thank you. Thank you, Mr. Constant. Thank you, Mr. Yates. All right, so seeing no further questions for Mr. Gates, who do we have from the public here to testify on this? Yes, sir.
Name's John O'Day. I want to know the boundaries of your consideration. 2 follow-ups possible. Detailed boundary line. Whoever can answer.
Thank you. So, who has an answer to that question? Boundaries.
Because you are tentatively trying to control 2 very large
We
properties.
have attached this ordinance in the handout. There's not, I guess, in black and white, you can see there that this applies earlier by that's what that's how it's on it. But I did mention that there be some jurisdictional issues with the national forest lands or Tibet state properties. And in board game regulations that says these areas are closed to trapping. Those lines are all shown on this map. You can see it in color on our website.
First follow-up, you have 2 combined to 1 federal reservation in that map. The one largest owner, the commander, has stated that there will be no trapping on the Air Force side. I have not spoken with the commander on the Army side. I would assume that the commander will say the same thing. He has to comply with the SACS Act, which most of you don't know Fred made. It's 552517. This is a contract with the state of Alaska that they will govern as best they can under certain regulations, fish and game on their base. And there is an additional problem with the private citizens trespassing, hunting, fishing, poaching, and trapping on both bases. That has to be addressed before somebody gets killed. Now, as Mr. Peterson and the Black Bear Hunt, Fish and Game has approved a fall hunt. But it has to go through the United States Air Force Base and their regulations.
Thank you. I think Mr. Gates has an answer or response.
Yeah, and I just want to clarify again, this ordinance doesn't do anything to regulate hunting and trapping, taking a game. It's just about trails that the public uses and a buffer zone where dangerous traps can't be placed. It doesn't say, big game hunts on Jaber or whatnot. That's still board game regulation. And you're right the way you described it, I think. That Jaber has to authorize any hunting activity on it.
Mr. Chairman?
Yes, Mr. Peterson.
Thank you, Mr. Chairman. And we're not trying to regulate trapping on native-owned lands that are owned by Kootenai, and also we're not trying to take over management of the base land either. We're just talking about trails within the municipality of Anchorage.
One follow-up. I believe the municipality has a regulation, ordinance, or whatever you want to call it, that when you take your dog or cat or possum or whatever that you had out in the wilderness, it has to be on a leash. I know that is true in town, and it should be true out in the bush or wilderness or whatever you want to express.
Thank you, sir, for your testimony. So I have Mr. Dunbar, then Mr. Constant.
excuse me. I wanted to ask Dean about concurrent jurisdiction. So, for example, when someone commits a criminal offense on JBEAR, they're often charged under the state law by state prosecutors with, in our case at least, they can be arrested by the APD because both sets of laws can apply. Obviously, the state and the federal government can supersede our law and say you are no longer allowed to regulate this thing. But usually in those cases, you can become more stringent, not less stringent. You can go more stringent. So my question to his point about both the federal lands, but also the Chugach State Park lands that fall within the municipality, are we asserting our own ability to have concurrent jurisdiction on trails that go into Chugach State Park, for example, with this?
I tried to make it explicit here that
Yeah, please point me if that's not the case, and just point me where.
We're not trying to do that state park. The Board of Game regulation for trapping in Chugach State. It's already in place.
Okay.
They have closed areas for trapping in certain parts of the state park. So lines 13 were otherwise permitted by the Department of Fish and Game. So that's sort of fluid, whatever their trapping regulations are.
But Dean, can I interrupt you for a second?
As far as the concurrent jurisdiction, it's the exact same thing. Sure.
So if the Board of Game or whomever controls the regulation reduced it to 25 in their next set of regulations, would our 50-foot buffers still apply in Chugach State Park?
50 yards.
50
That's
yards.
a very good question.
What?
That's a very good question. I would argue yes, probably, but as I mentioned at the beginning, there are some regulations that we got through that.
But I think there is this notion that from some of the emails we've been getting, this notion that we cannot regulate in Chugach State Park, or we cannot regulate on the federal lands. And I don't believe that's the case, but maybe it is. And I'm just wondering what your legal opinion on that is.
I think that it might depend on what law I'm talking about. So some laws apply area-wise. That's it could be prosecuted that there occurs on Chugach State Park or on criminal land or wherever. It's area-wide. I view this as being similar area-wide. But again, something I'm looking to before.
Right. And you've designed it in such a way where we don't necessarily need to enforce it on Chugach. And I think it's relatively unlikely that our code enforcement officers are going to go onto the federal or go onto JBEAR. But I do think it's important for us to recognize that within the municipality of Anchorage, we do have concurrent jurisdiction, unless we've been explicitly told that we don't, with the federal and state governments.
Yes, we have concurrent jurisdiction. This is preempted. And you mentioned the federal lands in JBEAR, and we do have consent from the government to animal control code enforced on JBEAR land as well. So I need to look at some historical documentation about federal government consent for local enforcement of local laws and see if this is covered. I think it is, but yeah, I need a little time for that.
Thank you, Mr. Chairman.
Thank you, Mr. Dunbar. So members of the public, I will get back to public testimony, but I got a bit of a queue here. So Mr. Constant, Mr. Dyson, then Ms. Zalatala.
Yeah, thanks. Barring some arcane layer of law that has to be addressed or approached, I think it's clear the intent of the sponsor is that it's strictly on muni lands. The idea of parts A on section 3 and part B on section 3, I think we just had a conversation about, describe that if there are other jurisdictions that have control of that land and say this is not okay here, that we actually aren't going to do that. That would be accepted. But otherwise, it's muni lands. And so essentially any muni lands inside the boundary of the municipality that aren't federal or state or military or tribal, I think that would ultimately, or private, come around as the barrier. And so then, of course, you did ask a question that's a little more nuanced, is do we have some arrangements with these other government entities to perform law enforcement, but I think the intent is clear that it's municipal land, not parkland that's owned by the state.
But that's, can I respond to that really quickly, Mr.
Sure.
Mayor? But that doesn't make sense, because we ban trapping entirely on muni lands here. So why is there a buffer? Trapping is forbidden on municipal-owned lands. So, I mean, I guess we've got to be really careful what we mean by muni lands. Municipal-owned lands, trapping is forbidden. So the buffer only applies in places that are within the municipality of Anchorage and are not municipally owned lands. And actually, but it also says trails on public land, so it's also, so I think it also means not on private. Public use trail means a footpath or on any public land, right? But then it says developed trail means a trail or footpath designated by the municipality. I don't know if we designate trails that go over private land.
As the drafter, the intent was more what Mr. Dunbar is saying, that Mr. Constant saying. Section 3's regulation of municipal land, Section 1, the new 1472 conference is going to be area-wide civil violation.
Anything further, Mr. Constant?
That's a surprise to me.
Thank you, Mr. Constant. Mr. Dyson?
Yeah, I think you have 4 questions on 2 subjects, and I'll condense them. Mr. Peterson, were the Alaska trappers notified of this?
Yes.
Anybody hear from that group? Good. I hope to hear from you. And how about the community councils and Girdwood? Were they given a chance to weigh in on this?
Good.
Yes.
Yeah.
So that's Ms. LaFrance saying yes.
Yeah, yeah, I'll be glad to hear from ours. Some of the best hours, days of my misspent youth were shooting rats at the county dump. And I think our solid waste management has not had a problem with rats at the dump, you know, and so on. But is there a permission or provision in municipal law or state that if there's a nuisance flourishing of some kind of mammals that we can rescind this, or a process to let us emergency trap for rats that are being overrun by rabbits or whatever? Who knows?
I wasn't really clear on what the question was.
Can we trap rats if they're communicating disease or a nuisance? Is there an emergency procedure to allow that?
Yeah, I mean, I think you're talking about maybe an official activity from municipal officials trapping rats. That wouldn't be prohibited, so I don't think so. I think we have authority to do that under our health code. We actually have rat infestation section in Title 16.
Okay, all right. The answer to both my questions was yes.
Mr. Peterson on this?
Yes.
Okay.
Thank you, Mr. Chairman. And I thought we were putting a provision in here that would allow Fish and Game to do trapping within Anchorage if there was a problem. Say we had a bunch of beavers and they were cutting down a bunch of trees in one of our parks and we needed to thin them out a little bit or move them somewhere, they would be allowed to come in and trap them. And that's a situation we actually had in East Anchorage a few years ago at Windsong Park. I mean, the beavers had probably got down 50 or 75 trees within a couple of weeks, and there weren't going to be any trees bigger than that left. And by wintertime, if something wasn't done, and so I believe the intent was that was going to be allowed.
Thank you, Mr. Peterson. All right, go ahead, Ms. Sullivan.
Thank you, Mr. Chair. I'm curious about the enforcement. I can see this leading to a lot of folks taking cell phone pictures of traps and saying, oh, I found it within 50 yards of the trail. So I just want to kind of flesh out, what do we imagine the enforcement of this is going to look like? Is it going to require an enforcement officer to see the trap live and in that spot? Photographic evidence? Can you talk to me a little bit about what we're thinking there?
I did send this to the administration asking what you think enforcement would look like if we were in. I don't have a clear answer to that yet, but in talking with Mr. Peterson about how it's being enforced, we would expect it to be more a complaint-driven type enforcement. So if someone finds trout or pets, unfortunately caught the trout, they call, and then maybe who code enforcement APD, somebody. APD has general police powers, they can cite on this section. I don't know if well. Someone goes out there, and of course, any evidence that meets the elements of this offense, but it's a civil offense, so it's preponderance of evidence that's civil. So I think that these arguments have been met by the situation.
Thank you.
Thank you, Ms. Alatel. And just for the record, we've been joined by Ms. Borowski, and then my apologies, Ms. Kennedy, but I forgot to put your name in the record. But you, for the record, Ms. Kennedy was here since the beginning of this work session. Any further questions before I go back to audience participation?
I have a quick.
Sure, Mr. Webb.
Pete, you had said that you want a provision in here so that to get beavers and so on. But if we were doing beavers, do they have to be near the trail? Or you say go ahead and get the beavers, just don't put the tractor in the trail?
Well, it would be written so as that Alaska Fish and Game would be able to, do trapping if there was a problem with an infestation of any kind of animal. And I would suppose that could possibly be bears as well. If they decided that, public safety is endangered because we've got too many bears or too many beavers or whatever it is, they would have they'd be able to still be able to do that. This wouldn't ban them from doing it.
Right, but it talks about distance from the trail and so on. So you're saying if there were a beaver infestation, a Fish and Game wanted to catch them, they would be allowed to put traps near the trail. Is it less dangerous because it's beavers? If it's dangerous, it's dangerous.
So, if I might, Mr. Chair.
Sure, go ahead, Mr.
What I
Johnson.
read again, coming back to sections A and B of Part 3, is that if traps are not allowed, and this is current law anywhere, then we have a scenario where if there is a reason for a controlled catch or trap, it's not allowed.
But that's not really what this is doing. This is just adding the separation from trails. That's current status of our trap.
No, you're right, but that question is before us because here it is on an ordinance, and so it's a concern that is mitigated.
Kind of tangential that came up.
Yeah, it's important. So it's not about putting traps next to the trail, but it's traps anywhere in case they're needed.
Thank you, Mr. Wilson. Thank you, Mr. Constant. Mr. Gates?
Yes, Mr. Peterson mentioned he thought that an exception was in here for that conduct. And I apologize, he did mention that to me. I don't think I answered it. But I made a note here that we should have an exception for official activity, whether they authorize things like that, if it's within that reference.
Thank you, Mr. Gates. Ms. LaFrance?
Thank you, Mr. Chair. It seems pretty clear that it's likely we'll probably have another work session on this and that there's some follow-up work to do. And so if we could focus on the public testimony for a big chunk of the time so we can get the feedback, so we can integrate it into making changes that can be made, I'd appreciate that.
Sure, absolutely, Ms. LaFrance. We can go ahead and go back to public testimony. Do we have anyone else who would like to testify on this topic? Yes, go ahead. State your name for the record.
My name is Cheryl Brooking. I work for the Alaska Department of Law, and I work with the Alaska Board of Game and the Department of Fish and Game. I'm the wildlife attorney. So there's just a couple of points that I made notes on here that I wanted to address. And I have talked to Mr. Gates. We had a nice conversation yesterday, and I understand the intent of this proposed ordinance. There are a lot of municipal ordinances, not a lot, there are several, and I know that he did look at those for guidance in drafting this particular ordinance. Not all of them are valid. I would encourage you to look at the Matsu Borough one. I think we're all comfortable with that one, because that one restricted trapping only on borough lands and did have the exception that I've heard discussed here for the need to trap when there's problems where you would need to do that. For example, you've got foxes nesting under a school. There could be all kinds of scenarios. That's just one. The municipality has the authority over domestic animals, and the state has authority over game animals. And game includes feral animals, domestic animals that become feral. The Board of Games adopts the regulations for hunting and trapping and for managing wildlife. The Department of Fish and Game also adopts its regulations for management and administration, and they carry out the board's regulations. So that authority stems from Article 8 of the Constitution, giving the legislature the authority to manage the state's resources, which includes fish and game. The legislature has in turn delegated that responsibility to the Board of Game for adopting wildlife regulations, including hunting and trapping, and to the Department of Fish and Game for administering those programs. There is no legal authority of the municipality to directly manage wildlife or hunting or trapping or fishing. However, the municipality is, as Mr. Gates said, a home rule municipality that has all other powers except specifically limited. That power that I've just described is limited. It belongs just to the state. You can do things like you have done and it shows up here. You can say, for purposes of public safety, discharge of weapons is prohibited within the municipal boundaries. And that's acceptable. That has an indirect effect on hunting, but you're not directly managing hunting. And that's usually the standard example that's given. However, things like setting seasons, bag limits, or methods and means are within the purview of the Board of Game. For example, requiring identification tags on traps. That would be a Board of Game authority. One comment on the J-Bear question that came up. There is an agreement, it's referred to as the NRAM under the Sykes Act, that the state has with J-Bear. Trapping does not occur on J-Bear. The Board of Game does have the authority to close areas and has done so. I do have some of the same questions that have been raised today that Mr. Gates and I talked about, and that he acknowledged he'd like to look into a little bit more, like because this is being put forth as an area-wide regulation with no exception for addressing any nuisance animals. You know, there's some issues in there that he agreed maybe as this goes through the process could be worked on a little bit more. The Board of Game does have regulations allowing people to trap nuisance animals. There's no season or bag limit on animals that are defined in regulation as nuisance. So if that helps answer one of your questions, if you have voles that get in your house, you can catch those. One question that I do have that just kind of came up to me today that I didn't talk to Mr. Gates about is this limits sport and commercial trapping. Commercial trapping includes pest control where people have a commercial license to control pests. And I would just ask you to consider whether you want to actually ban that. And I'm here to answer any other questions. I think I hit some of the highlights. I just wanted to share that with you, and thank you for holding this work session.
Thank you. So before I get to you, Mr. Constant, I just want to get a show of hands. Anyone else in the audience that would like to testify so I can manage time? One. This is going to be your chance. Otherwise, I will. Okay, just one. All right, Mr. Constant.
Thanks. Interesting that you said that the Muni has the authority to ban discharge of firearms within the boundaries of the Muni. And so would the same argument apply then to traps? Right? If a firearm, we can regulate its application, then wouldn't it be the same for a trap? Because a trap serves the same function, a means of capturing an animal.
The state's position has been that the municipality can control the placement of traps on its own property.
But that's a different issue. It's not placement question, it's the application. Again, this maybe is a legal debate, but I heard you say we can say no firearms discharged within the municipality, except at authorized locations, because we have shooting ranges. But then it seems parallel to me that we could say no discharge within the municipality. So maybe that's just an area that we have to think about.
There may be specific state and federal laws that could override that municipal ordinance in certain areas.
Yeah, could be, and I agree there are some areas. So thank you. That was.
Thank you, Mr. Constable. Ms. Kennedy.
Thank you. Are there any restrictions or laws in the gaming law for trapping that basically keeps people from touching traps that aren't theirs? I mean, what kind of laws or restrictions or whatever are in place that actually protect the trapper's trap?
Yes, that's a very good question, and there are regulations in place. It is a violation of state law to interfere with someone's trap.
So if somebody sees something and they're out wandering around and they see it and they go, oh, I don't like that trap, I'm going to set it off, disarm it, whatever, they cannot do that
That's
as
correct.
a member of the public. Okay.
Thank you, Ms. Kennedy. Sure, Mr. Constable.
If it's illegally placed, same.
I don't know how far down the rabbit hole to go on these types of questions, but if someone does see an illegally placed trap, the troopers always request to be contacted. If it's within the trooper's jurisdiction, the municipal police also have the authority to enforce state fish and game laws. So they can contact the Anchorage police or the state trooper.
Thank you, Mr. Constable. Mr. Weddleton.
So the broad sweeping message of your discussion there is we're not allowed to do this. It's kind of my gathering, but apparently Matt Sue has done something similar and they are allowed to. Did I miss something?
What Matt Sue did is adopt an ordinance that only applied to restricting the placement of traps on borough-owned lands. And they made exceptions for certain circumstances where fish and game or someone operated by fish and game could come in and trap when necessary.
We're much broader here. We're saying Chugach State Park and so on. Or primarily, that's our main thing. Chugach State Park, which is in the city but not owned by us. And you're saying we can't do that.
This is area-wide. It covers all state and federal lands. And I would question that.
You just question it, or you're telling us factually we can't do it?
I don't know how this is ultimately going to look. The way it's written, I think that it would not survive certain legal challenges.
No.
I'm sounding like a lawyer.
Thank you, Mr. Weddleton. And Mr. Gates, then Mr. Constable.
I don't know if I agree with that last remark, but I wanted to add that I have read Matt's ordinance, and I have it. If you'd like it, Mr. Weddleton, listed these some numbers, I can send it to you. And I would compare what Matt Seaborough's ordinance did to our existing code in section 3, right, in Title 25. That's just about municipal land, that section. So the new section 1470, 200, and section 1, that means that this is an area of restriction, so that's what's different from what Matt Seaborough did. And I'll send it to you. You've also noticed that theirs is much longer. And they also specified somebody at a borough-owned property by me at this park and that park, and so forth. And I understand that in the process they had to remove a park that wasn't actually owned by the borough. So that's one I guess, legal difference between what they did and what we did in this section 1.
Thank you, Mr. Gates. Thank you, Mr. Weddleton. Mr. Constable.
So just to come back, you used the phrase "won't survive certain legal challenges." When you said certain, did you mean particular, or did you mean inevitable? You know what I mean? Like certain challenges. This is a challenge, and that challenge, and that challenge, or a certain challenge, legal challenge.
The state is not threatening to sue the municipality.
Okay, and I was just trying to figure out what the word certain means, and so playing attorneys, right? So, okay, thank you.
Thank-
With several varieties of challenges. Is what you're- yeah, thank you.
Thank you, Mr. Constant. Mr. Dunbar.
Yeah, so I was having a similar thought, and I think the crux of the issue gets back to what Mr. Constant said about if we have the ability to say you can't fire a gun in a municipality, and that goes way beyond just municipally owned lands, then the logic to me makes sense that we could say you can't set a trap in certain places. You have to be a certain distance away from people. But to get to what you just said there, Mr. Constant, what would happen, I think, is if we tried to enforce this on someone, so we tried to issue a fine, then they would challenge it and say you were preempted. And that's, and correct me if I'm wrong, the attorney from the Department of Law, but that's how it would. The state wouldn't actively sue us. It's when we try to enforce it on someone and try to enforce a fine, they would challenge us in court, and then there'd be litigation, and actually, I don't know how that would turn out.
Thank you, Mr.
Point of order. There's no prohibition of discharging firearms in a municipality, only if there's a chance of it just hurting someone else. It's even at the top of page 5.
Which then actually hones the point in even better,
Yeah.
that there are certain circumstances in which
Sure.
it might be reasonable to apply a higher standard to where a tool that could cause harm is applied. I think that actually is hopeful, because you're right, reason is really important in this.
Thank you, Mr. Dyson. Thank you, Mr. Constant. Mr. Peterson, then I do want to get to our last testifier.
Okay, thank you, Mr. Chairman. And so the crux of the matter could get down to what home rule allows the municipality to do. And I think that may have been litigated before. Mr. Gates, I'm sure, probably has information on that. Thank you.
Thank you, Mr. Peterson. All right, welcome, sir. Go ahead, come up and say your name for the record.
Yeah, I'm Neil Taylor, and I'm supporting this, and I did a lot of work with the Alaska Safe Trails Group up in Matsu, and in the process, I just agreed with the Department of Law.
The recorder's over here, so if you could come up so the recording will pick you up better. Thank you.
Excuse me, I'm an attorney. I'm Neil Taylor, and I worked with the Matsu Borough, or with the Alaska Safe Trails Group on their ordinance, and have spent a lot of time looking at this. And I will get to all of you a memorandum of law citing the case law, our Supreme Court, the Constitution, and basically an ordinarily enacted ordinance is presumptively valid by a home rule municipality. And that, anyway, I'll get you all those citations in the law, and I think it's quite clear that on this limited basis, as a public safety issue, you do have authority throughout the municipality. Thank you.
Thank you. Mr. Constant.
I just would offer that all these emails from your supporters are kind of awful. And I understand the gravity of the question, but if I have to see another picture of a dog in a trap, I'm going to just have a broken heart. So I just want to share that. It's been very brutal.
Thank you, Mr. Constant. Mr. Peterson.
Thank you, Mr. Chairman. You know, I got an email from a gentleman from Girdwood yesterday whose dog was caught in a trap during this winter, and the trap was set 10 feet off an established trail. And so I think, and he was fortunate enough to be able, because he was a firefighter and in good physical condition, to free his animal from that trap before the animal died. Most people might not have been in physical shape enough to have done that or had the knowledge. And so I think we were extremely fortunate that wasn't a human that was caught in that trap. And so for me, public safety has got to be the #1 priority, and that's the reason I'm bringing this. I'm not trying to tweak anybody's nose. I still think there's a way for us to make this work, and so we will, postpone this and continue to work on it. Thank you.
Thank you, Mr. Peterson. Ms. Alito.
Thank you, Mr. Chair. Mr. Pewson, do we know how many reported incidents we're talking about on a yearly basis? We're hearing from folks, obviously, who encounter these issues. It'd be something good to have. I mean, I know that may underreport, but it'd be good to kind of put some ideas on how much this is happening.
Well, in my opinion, once is too many. And I mean, the number of emails I've got from people who are just finding out about this, who've had an experience where their animal was trapped, makes me believe that's probably happening more often than we're aware of.
Thank you, Ms. Hamilton. Mr. Gates.
Like Mr. Peterson said, when we first started this, I asked him the same question. How many are we talking about in these past 5 years, for example? Well, since this ordinance was introduced, I think we've learned a number of more than in the past 5 years that we didn't know about when we started this project. So I think there's a number of unreported incidences out there.
Any further comments?
Are we wrapping up?
Yeah, we got 2 minutes. So we can eat it or not. All right. I'm going to assume Mr. Gates has nothing further to add.
I'm good for now.
Okay, thank you. All right, so this work session is over. We have 2 minutes until the next one.